Very good morning to all younger advocates and also the general public who are watching this video. Previously on Transfer of Property Act, three videos were in circulation. First video is about preliminary, what transfers are not covered under Transfer of Property Act and how many chapters, how many sections. And video 2 is regarding interpretation clause. What are the definitions of immovable property, movable property, attestation? These are all discussed in video 2. Video 3 is another important topic is what is notice, what is constructive notice. So, these are all discussed in video number 3, that is section 3. Then now coming to section 4. Section 4 is nothing, is very simple. As far as section 4 is concerned, enactments relating to contracts to be taken as part of Contract Act. The chapters and sections of this act which relates to the contracts shall be taken as part of the Indian Contract Act 1872. And section 54, paragraph 2 and 3, section 59, 107 and 123 shall be read as supplemental to the Indian Registration Act 1909. సో ఏంటంటే సెక్షన్ 4 కన్సర్న్ కాంట్రాక్టులకు సంబంధించిన శాసనములు కాంట్రాక్ట్ చట్టంలో భాగంగాను రిజిస్ట్రేషన్ చట్టానికి అనుబంధంగాను పరిగణిస్తుంది అన్నమాట సెక్షన్ 4కి సంబంధించి. సో వేర్ ఎవర్ దేర్ ఆర్ వర్డ్స్ పర్టైనింగ్ టు కాంట్రాక్ట్స్ యూ హ్యావ్ టు గో టు కాంట్రాక్ట్ యాక్ట్ ఫర్ దేర్ deriving some meaning on those terms if reference is required. Now coming to section 5. What is section 5? Section 5 is concerned transfer of property. What is transfer of property and its definition as far as section 5 is concerned? It is defined to mean any act by which a living person conveys property in present or in future to one or more other living persons. Already actually when I am discussing about preliminaries, video number 1 also it was stated like that. One or more other living persons in present or future to one or more other living persons or himself, as when a man makes a transfer in his capacity as an executor to himself in his private capacity. So here what is meaning of himself? For instance, when a person vests the property in trust and himself becomes the sole trustee, or when a man transfers property in one capacity to himself in another capacity, as when a man makes a transfer in his capacity as an executor to himself in his private capacity. So, if some trust is created and he is the main person in the trust, becomes trustee, when a man transfers property, he is a sole trustee, then he has to transfer a property, his property on his name only, but in the capacity of trustee, sole trustee. So, that is what it meaning. Then himself and one or more other living persons. Not only it does not mean that one living person, he can make a conveys property to one or more other living persons. So, this is being the definition of what is transfer of property as defined in section 5. Then here one thing may be noted, it is the word person is mentioned in the definition, but here the clarification is that person includes not only human beings but also a company or association or a body of person, whether incorporated or not. Even a juristic person also is included in this word person. Here the kinds of properties, the act contemplates the some types of kinds of properties, kinds of transfers. What are all those? Sale, mortgage, lease, exchange and gift, etc. Then what is living person? Expression living person in this section includes corporated and incorporated companies registered and unregistered associations and partnership firms. So, all these bodies can affect transfer of property in their business collectively or in firm names. An idol is a juristic person capable of owning property, but is not a living person, and therefore a dedication of property to an idol is not a transfer and need not be made in a writing or by a registered instrument under section 123 of the Act. So, as far as the idol is concerned. So, because this is very important, an idol is a juristic person capable of owning property, but is not a living person, and therefore a dedication of property to an idol is not transfer and need not to be made in writing or by a registered instrument under section 123 of the Act. But what actually in the practical sense, what is happening? Suppose you wanted to donate some land to some temple or idol, you are sometimes you are registering also the document. Of course, the registration of document is a proper way of conveyance, but due to lack of knowledge, so we are also registering some documents which need not to be registered. But what here it is said is, the dedication of property to an idol is not a transfer and need not to be in writing or by a registered instrument under section 123 of the Act. Here what is the, see, once we do not go to fundamentals, suppose some dispute comes before the court that some dedication is made to some temple and other side takes a plea that it is not registered, that hence it is valid, not valid. So, now you have to safeguard the interest of idol, then what you have to put up a defense. That is what where it comes when you go to fundamentals. You can take plea under this section 5, section 5 of Transfer of Property Act, that it is not a transfer as contemplated under section 5 of the Transfer of Property Act, and it need not to be registered. Until unless you bring this fundamental aspect to the knowledge of the court, normally court also basing on the material before court, it may give that this is not registered, it is not invalid, but that is not correct. So, the fundamentals are so much important, because everything is not a transfer that requires registration or stamp duty. Suppose somebody by virtue of a registered document dedicates some property to the idol, okay, it is good, nobody is, suppose in case in olden days somebody on a some paper they writes that we are dedicating this property to this temple and it is to be used for dopa depa naivedyam, what not. So, here suppose a dispute comes and other side questions that it is not valid since it is not registered, then you have to take shelter under section 5 of the Transfer of Property Act, because here you know you have to bring it to the knowledge of the honorable court about this aspect. Suppose if you do not bring it to the honorable court, the court may pass decree and judgment basing on the material before the court, placed before the court. There is no presumption that judge knows law in law, because you have to apprise your client's rights and also the legal position before the honorable judge. So, you may find sometimes surprisingly that some judgments also reported, since it is not registered, so dedication to the idol is not valid under law. Because why such type of judgments emerge? Because if you do not place sufficient material before the honorable courts, that type of judgments will emerge. No doubt in the appeal, if some correct fitting advocate comes, that will be satisfied, that is a different thing. But as an advocate, since in the ab initio stage itself, in the entry itself, you have to know, because you are fresh from colleges, you may not understand the scope of these fundamentals and definitions, but now you have to understand, having come to the profession, to safeguard the interest of our client, that may be a temple, that may be an individual, that is a corporation, that is an association, whatever it may be. So, this is the most important aspect, that is why I am repeating it. That is so. Now, here transfer of future property how far valid? According to the Supreme Court, the words in present or future in section 5 qualify word conveys and not the word property. The expression property of any kind does not include future, non-existent property. Therefore, a transfer of future property is not as such valid in India, but a conveyance of such property may be valid as a contract to assign, and when the property comes into existence, equity fastens upon the property and contract to assign becomes a complete assignment. Here in section 5, in present or in future, if a property is to come into existence in future, this can only be a contract to transfer such property when it does come into existence, and such a contract will of course have to be supported by a consideration. If the transfer is for consideration, equity will allow specific performance of agreement, but if the transfer is gratis gift, there will be no enforceable contract. Thus, a gift of future property is void. This is known as rule in Hall Road versus Marshall. So, here I will tell you what is this concept, transferring a future property. What is this concept? Here, this is also called technically spes successions. What is spes successions? A transfer by another person who subsequently acquires interest is in a property transferred. Here that is one thing, that is section 43. But what is spes succession? I will give you an illustration. Suppose one gentleman A executed a will in favor of his wife B. So, he is alive, that gentleman is alive. So, the will did not come into force, but B, wife, she promised a gift to her daughter during the lifetime of testator, that is her husband. Then afterwards what happened? Her husband, normally in the old age people behave differently, he changed his mind and he cancelled this will which is bequeathed to his wife, and he executed the will in favor of somebody, some close relative. So, now the daughter sued mother that she promised to give so much of 1 acre or 2 acres of property as a Pasupu Kunkuma during my marriage. So, she filed a suit. Can she succeed? So, answer is no, because it comes under spes successions. It comes under spes successions. So, here what is this? Because on hope of getting some property in future, she promised her daughter that she will give 2 acres out of that property promised during the marriage of her daughter. Later daughter sued, but the father changed his mind and he executed a will, cancelling will in favor, executed in favor of his wife, and he executed a will on somebody's name. So, he is still alive. So, now will daughter succeeds? She will not succeed. So, but in this sometimes section 43 of Transfer of Property Act comes into rescue of the affected person in certain conditions. What is that 43? Transfer by unauthorized person who subsequently acquires interest in the property transferred. So, here what is that? Somebody represented that some 2 acres of property belongs to him and he executed an agreement of sale and taken considerable amount of money. But in fact, he misled, as on the date of that agreement, we could not acquire any interest in the said property, scheduled property of agreement. The agreement is in force, but later during his family settlement, later he acquired interest on the property of the scheduled property of the agreement. Now, the agreement holder can insist that now you got right in this property, you execute a sale deed. So, that is under section 43 of the Transfer of Property Act. So, special successioness, and in that also other side of the coin is section 43 comes into rescue sometimes under these circumstances. So, you must know this. Then as far as special successioness is concerned, there is a judgment reported in AR 1962 Supreme Court 847. This I will also give the names of the parties, so that if the page number happen to be wrongly noted, you can also try on the page number, the name wise. Jamma Masjid versus Kodi Manendra Devaya. This is the party's name. Here at para 12 and para 7, para 12, here in this, in the illustration, when A sold field Z to C, he had only a special successioness. So, he should have not have sold, but he having subsequently inherited it, C became entitled to it. Just now I have told. This concept just now I have told. Here para 6, the sole point for determination in this appeal is whether a transfer of property for consideration made by a person who represents that he has a present and transferable interest therein, while he possesses in fact only a special succession, is within the protection of 43 of the Transfer of Property Act. So, when it will be in protection? When the contract is in force, and provided the executant acquires the right subsequently. If he does not acquire the right subsequently, gone. So, section 5, under section 5, this is one thing, one restriction. Then coming to the next is year 1967 Supreme Court 401. This is Commissioner of Income Tax West Bengal Calcutta versus Jugal Kamalapat. It is para 11. Here the deed of relinquishment in this case was in respect of a individual interest of 3 Singhania brothers in the assets of the partnership firm in favor of Kamala Town Trust, and consequently did not require registration, even though the assets of the partnership firm included immovable property and was valid without registration. As a result of this deed, all the assets of the partnership vested in the new partners of the firm. So, it is in the somebody executed a deed of relinquishment in respect of individual interest of 3 brothers in the assets of the partnership in favor of one trust, and consequently did not require registration, even though the assets of the partnership firm included immovable property. So, what is this meaning is whether a relinquishment is a transfer as contemplated under section 5. So, depend upon the facts of the case, what relinquishment does not convey anything, what right he is having, he relinquishes in favor of partnership firm or partners, whatever it is. Under those circumstances of the case, they said that it is not coming under section, it is not coming under the definition of transfer as contemplated under section 5, and it needs no registration. That is only the purport of this judgment. Then next comes deed of release and transfer of title. So, deed of release comes under transfer as contemplated under section 5. See, section 5 is only definition is given in the act. What is definition? What is transfer of property? But these are all the illustrations I am trying to bring, so that you will know what type of transfers or what type of alienations are comes under transfer of property as contemplated under section 5. So, but nowadays what is happening, our financial needs increased by leaps and bounds. So, if you have an unregistered family settlement or oral family partition, these things only in case of court disputes, if there is a issue that whether past transaction of settlement are valid or not, you may get good judgment in favor of you, in your favor. But problem here is that Today the financial problems increased by leaps and bounds. Everybody needs something, some finance for some urgent finance for his day to day life. So that is why now this system is almost ignored, and this is only in extraordinary cases, 100 and in 100 about 10 cases or even 5 cases. But not what everybody we are advising is, it is better to have a registered partition, so that what happens, see now if you want some loan for your agriculture purpose or your for study of your son or daughter, if you present unregistered documents, bank will not, nationalized bank will not grant any loan for that purpose, even for building and all. So what we have to do, compulsorily it is better to register the document in order to have a complete rights and in order to avail this type of facilities. Simply because there is an exemption for settlement deed and you want to execute a past transaction, hence you need not to pay stamp duty and registration. If you drop that document for your enjoyment purpose, it is okay. But if you want to make it a public, you want to take loans or you wanted to do some other businesses, that document will not be accepted until it is registered. So only because under in the concept of section 5, I am only analyzing this issue. That is what I am telling, and I am also telling that it is only in case of court dispute this will come to your rescue, but in normal life, if you do not have a registered document, you will suffer in so many ways. That is what I wanted to bring to your kind notice. Now next 6, here list pendants and legislation, in this case 1976 3 Supreme Court cases 602. Here you see in under section 5 of the Transfer of Property Act, you need not to transfer whole rights. Suppose mortgage is there, lease is there, you are only conveying limited rights. So under these circumstances, a landlord and tenant relationship will come under doctrine of lis pendens. So that is the point that is dealt here. Here rent control and eviction, subtenant. Effect of subtenant being declared by the statute to be a tenant directly under the superior landlord on the suit for ejectment then pending, held statutory change in the landlord and tenant relationship does not amount to an alienation of property so as to attract the doctrine of lis pendens. So the relationship of landlord and tenant, if there is a statutory change in that relationship, does not amount to an alienation of property as contemplated under section 5, and it does not attract the so as to attract the doctrine of lis pendens. So this is the concept in this matter. Then coming to next, this already dealt, personal asset into partnership firm. Here partner firm bringing his personal assets, shares and limited companies into firm as his contribution to its capital effect amounts to transfer of asset under section 45 read with 247 IT Act. No profits or gains within section 45 can arise to the partner from such transfer. Considering the firm to be genuine held, consideration for transfer of assets in such case not covered by section 45 and 48 and so not taxable. So this is with respect to the reading with respect to the Income Tax Act. Here they say that it amounts to transfer of assets under section 45 of the 45 read with section 247 IT Act, but however such assets in such case not covered by section 45 and 48 and not taxable. That is what the concept of this judgment. Then next, partition. Just now I have said about partition. Actually there were so many conflicting judgments that some courts held that partition is a transfer. Some court held that partition is not a transfer. But in year 1966 Supreme Court 432, it is held in para 13 that allotment of one parcel of property belonging to an individual Hindu family to an individual co-partner as a result of partition is an acquisition of said property by transfer by the said co-partner within the meaning of section 14(6). In our opinion, High Court was right in coming to conclusion that 14 did not create a bar against institution of application by respondents for evicting the appellant. So, here instead of respondent alone has become landlord of the premises. See, the landlord and tenant, in that concept this is discussed. In this case, it is held that a partition is a transfer. Previously, they held that it is not a transfer. Depend upon the particular facts and circumstances of the case. But now, it is as I stated earlier, it is under the concept of section 5 of the Transfer of Property Act. That is why I already stated that the partition deeds and all, forgetting about the definition of Transfer of Property Act under section 5, you must and should you have to go to registry office and register for the convenience, for your convenience, and to utilize this document in day to day life for the purpose of your own getting some loans from bank for your necessities. If the document is not registered, it is of no use. You can enjoy the property, but it is of no use. Moreover, state governments also amended Stamp Act and Registration Act by their state including sections. So, they made some documents compulsorily registrable. So, in that head, if this document covers under compulsorily registrable head, you have to register it. There is no other go. So, you have to follow those latest amendments. These are all the old decisions where why I am bringing into notice is under section 5, under definition of Transfer of Property Act, there was so many judgments either side. At one moment they used to say partition is not a transfer, in another moment they said it is a transfer, Bombay High Court and all. So, like that depends upon facts and circumstances of the case, and also time, and also those days act may not be amended. There are so many factors are there, but basic, in order to know the basics, I am only enlightening. Shares. So, shares are concerned, shareholders' right of transfer is only subject to restriction if any contained in articles of association. So, shares are concerned, it is a transfer of immovable property, the mobile property. The shares are mobile property, and their transfer is regulated by the articles of association of the company. Articles of associations are the regulations of the company binding on company and its shareholders. Therefore, the only restriction on the transfer of shares of a company is as laid down in its articles, if any. A restriction which is not specified in the article is not binding either on the company or on the shareholder. The vendee of the shares cannot be denied the registration of the shares purchased by him on the ground other than that stated in the articles. So, these are all, this is a shares is a transfer of mobile property, because in the video number 1, what I also brought enlightened that it covers, some sections covers transfer of mobile property also. Then coming to family agreement, as far as family agreement is concerned, it is year 1990 Kerala 226. 226, I already that subsequent family agreement is binding on the parties. I have already discussed this. Suppose a family settlement has taken place about 2 years back, and everybody is in possession and enjoyment of their properties in pursuance of that oral family agreement. So, in order to put it in writing to avoid further disputes, the past transaction is reduced into writing. So, that needs no registration as for some of the judgments of the Honorable Supreme Court and High Courts, but it is only in case of court disputes. But if you have a settlement without registration, you will be in a public life, it will not be entertained for giving loans and all. Unregistered settlement deed, normally they don't entertain. Because why? Because nowadays technology has improved, at the same time the fraud also is increased. Suppose if you unregistered settlement deed, if banks are entertaining, so one may present one unregistered settlement deed for taking loan, and somebody may create another one, because since it is not unregistered, there are chances of duplication. That is how the banks will not take this type of documents. Then here section 5, 7, 8 and 54, here the Hindu minor ratification on attaining majority. Here para 12 page 81, sale by the guardian of a Hindu minor of minor's property when there is no legal necessity for such sale is not void, but is voidable in the sense that it is required to be set aside by the minor by a suit, and unless the transfer is so annulled by a judicial decision, it would remain a valid transaction binding on the minor. It has however been rightly pointed out by Mr. Mittar that the said decision is clearly distinguishable, because there the sale was by the natural guardian and for legal necessity, which was otherwise established. That was not a case of transfer by a de facto guardian as in the present case. In the case of a transfer by a de facto guardian, the position however is somewhat different. Our attention has been done so and so. An improper alienation of property belonging to Hindu minor by his de facto guardian cannot be held to be binding on the minor until it is set aside. Although it may be voidable in the sense that he may affect either to ratify it or to avoid it by treating it as nullity. So, this everybody knows. The minor has always had an option to question the document the moment he attains majority, and within 3 years of attaining majority, he has to question the document. If he does not question the document, that will become final. That is why the purchasers should be aware while purchasing the minor's property, and there should be some remedies like taking permission from the district court, making some deposit in as far as the share of minor is concerned until he becomes major. Such steps, by contacting on a senior advocate of civil, you can take some steps when it is compulsory to purchase a property of minor. Then again the partition in Hindu joint family. The partition is not actually a transfer of property, but is analogous to an exchange. Mukherjee J in a Calcutta case said that partition signifies the surrender of a portion of a joint right in exchange for a similar right from a co-sharer. Spencer J in a Madras case said that the partition affects a change in the mode of enjoyment of property, but is not an act of conveying property from one living person to another. In Sarin versus Poplal, Gajendra Gadkar CJ has observed that the true effect of partition is that each co-person gets a specific property in lieu of his undivided right in the respect of the totality of the property of the family. The correct view it is submitted is that a partition is a transfer and therefore strictly not governed by the Act, but that many of the provisions of the Act may govern partitions as embodying rules of justice, equity and good conscience. So, that is what I said, because there is conflict of judgments as far as partition is concerned, but ultimately that is only at the time of court disputes this all comes, but in the normal parlance one kindly registered the partition deeds so that you will get some facilities, banks, loans and all. So, here today this is and then another last but not least is right of easements. Suppose right of easement also not a transfer as contemplated under section 5 of the Transfer of Property Act, because suppose in a village some dispute as to easementary right comes, then they enter into some compromise and compromise is reduced into writing. So, that is filed in the court. And now, the question is it need to be registered or not? So, as for section 5 of the Transfer of Property Act, it is not a transfer, it need not to be registered. But you find so many judgments either way, because if these aspects are not brought to the knowledge of the court may likely to give a judgment basing on submission of other side that easementary act has to be registered. So, compromise easementary right which is in dispute already existing is compromised between the parties, it need not to be registered. So, that because it is not coming under transfer, no property is conveyed virtually. So, not coming under Transfer of Property Act, but we have to bring to the knowledge of the court about this aspect. So, here today under section 5, what is transfer of property from living person to one living person or other living persons, a transfer or an act. Not only that, what transfers comes under this, what are all not transfers, that are also some judgments and illustrations I have given, so that you can understand that subject more clearly, section 5 of the Transfer of Property Act. So, next time we will go to section 6 is another important section. Section 6 is another very important. So, section 5 is only definition part is I have said, and also what are all coming under section 5, what are all not coming under section 5 as contemplated in various judgments of the High Courts and Honorable Supreme Court. So, today thank you very much. Again we will meet in another video with section 6 of the Transfer of Property Act. Thank you.
కోటి ఆశలతో వేల ఊసులతో రెండు మనసులను ఒకటి చేసే కమనీయ దృశ్య కావ్యం కళ్యాణం. మీ ఇంట జరుగు శుభ వివాహ వేడుకలలో మన సంస్కృతి సంప్రదాయాలు ప్రతిబింబించేలా సుమనోహరమైన స్వర్ణ వర్ణాల సంగమంతో ముస్తాబైంది మీ చందన వారి కళ్యాణ కోవెల. అందరికంటే విభిన్నంగా ఎక్కువ కలెక్షన్స్ చౌక ధరలకే నవవధువుల కోసం ప్రత్యేకంగా కాంజీవరం నేతకారులచే రూపుదిద్దుకున్న వేవేల వర్ణాల పట్టు చీరలు, కళా నైపుణ్యం కలగలిసి మీ అభిరుచికి అద్దం పట్టే పట్టు పదనిసలు, అప్ టు డేట్ కలెక్షన్స్ తో మీ ఇంట వివాహ వేడుకలకు కావలసిన డిజైనర్ సారీస్, ఫ్యాన్సీ సారీస్, పెట్టుబడి చీరలు, లేడీస్ చుడిదార్స్, డ్రెస్ మెటీరియల్స్, గాగ్రాస్, జెంట్స్ షూటింగ్స్ అండ్ షర్టింగ్స్, మెన్స్ బ్రాండెడ్ రెడీమేడ్స్, కంప్లీట్ కిడ్స్ వేర్ కలెక్షన్స్ తో మీకు అపూర్వ స్వాగతం పలుకుతోంది మీ చందన వారి కళ్యాణ కోవెల. మా జ్యువెలరీ విభాగంలో బంగారు ఆభరణాలపై అతి తక్కువ తరుగు, మజూరీ లేదు. వెండి వస్తువులపై అతి తక్కువ మజూరీ. విచ్చేయండి చందన బ్రదర్స్, ఏలూరు మరియు జంగారెడ్డిగూడెం.